are you able to share your screen?
Yeah. Can everyone see that?
Perfect. I could see that.
Okay, perfect. Let me know when, am I good to start?
Yep.
So thank you for having me. It's quite an honor. Last time I did this, obviously it was in person in front of a big crowd, so it's a little bit different this time on Zoom, but I guess that's the world we're living in, and we're getting used to it.
See, for me, this is so much better, Michael, because now I can actually listen to what you say instead of I'm like a headless chicken trying to put things together.
It's sort of funny because now I can see myself presenting, so it's a little bit strange. So just a little bit of background about me and my firm. The firm's called Kutner Law LLP. There's 3 lawyers that work at the firm, and we have 5 other staff. Our focus really is on helping dentists on the business side. So my day-to-day is helping dentists either incorporate dentistry professional corporations, review associate agreements, and buying and selling dental practices. Right now, I probably have about 15 to 20 dental practices on the go that we're helping either acquire them or helping our clients sell them. You know, during COVID, during the actual shutdown, things really ground to a halt. But since things have reopened in the spring and going to the summer, and even now, even though some of the big, Toronto, Peel are in the gray zone, there's still transactions going on. Dental practices have not shut down, and people are still buying. So, that's good news for dentists. That's good news, especially for sellers and buyers out there looking. The deals are still happening, and we're as busy as ever, if not more busy, as it seems like people are trying to catch up from a few months in the spring that everything was closed. So the point of my presentation today is really to take you through your career from a legal perspective and try to hit on the highlights that you may need a lawyer for, right? So right from the beginning, from your first contract that you're likely going to see, from an associate agreement all the way to buying your dental practice. I'll talk a little bit about selling, but won't get into too much detail about that. Now, just to tell, I've told you we do business law. I don't do litigation, or if you get in trouble with the RCDSO, which I hope no one ever will, we don't do that type of law. There are other lawyers, regulatory lawyers and litigation lawyers that we do refer to that handle those matters. So we're only doing the good stuff. We don't get into the bad situations. So as I said, the first step of most dentists' careers is becoming an associate of a dental practice. Now, I would say that applies to probably 95 to 99% of dentists who are coming out of school. They become an associate of a dental practice. Now, I know foreign trained dentists, some dentists who have certain connections, they may want to buy a practice right off the bat. And we have had many situations where I've acted for dentists who are still in dental school, going to graduate. I just did in the spring, we closed 2 deals for a dentist who was out in Australia. She was going to graduate and get licensed middle of February of this year. And we closed the 2 transactions 2 weeks after she came back from Australia and got licensed. So that is the rarity. Generally, our recommendation is for you to get some experience, at least a year or 2. You may have owned practices previously, but it is always good. And the banks also like to see that you've gained experience in a dental practice in Ontario. It is tougher to buy practice right off the bat. So a year or 2, get your feet wet in Ontario, and then you can go out and start looking for buying practices. But generally, that's where we're going to start, is you're becoming an associate of a dental practice. So usually the first contract that you're going to be presented with is that associate contract. So I wanted to sort of tell you what are those concerns that you may be feeling when you get presented with that contract. Now, there's a million different types of forms of contracts. And in fact, sometimes, I don't recommend to my clients who own practices, but sometimes the principals of the practice won't even require you to sign a contract. And frankly, the purpose of the contract is generally for the protection of the principal. They own the goodwill of that dental practice, and they want to make sure that that's protected, that you're not going to open up practice next door, steal their patients, steal their staff. So they want to protect themselves. From the associate's perspective, as a lawyer, I don't particularly mind if you aren't presented with a contract, and if you don't sign a contract, that opens you up and allows you to freely practice anywhere you want without restriction. So certainly don't be scared if you don't get presented with a contract. Generally, it's going to be to your advantage. So I have a note here. If you work in a rural town in Ontario, you may not have an associate agreement at all. Now that's a generalization, of course. But sometimes I don't mean to generalize. Older dentists in smaller parts of smaller towns in Ontario may not be as concerned as a dentist who may be in Toronto. They may not come to the presentations like this as much. So generally, from what I've seen, there's less chance you'd have a contract, and if you do, those contracts tend to be less onerous in terms of what the restrictions are. On the other side of the spectrum, if you're working for one of the large dental corporations, 100%, even before you step foot in that door, they're going to be presenting you with a contract that is probably going to be a lot more onerous than one of the contracts you may see if you're working for a single dentist who owns one practice. So one of the big concerns coming out of school and to most dentists and from the associate perspective especially is, how are you going to be paid? So generally, in most cases, you're getting paid based on what your collected billings are. So what our collected billings generally means gross billings for services rendered that are actually collected by the principal. Now keep that in mind when you're interviewing for positions. You want to keep that idea of collections in mind, right? A question that you may want to ask the principals, well, what's your accounts receivable? If that's a disorganized dentist, maybe they're not collecting a lot of their accounts receivable. That's going to impact you directly because that's going to impact what you're being paid. If you want to be in the mid 90s in terms of what the accounts receivables are, if that dentist is telling you, well, I collect 75 to 80%, that's going to impact your bottom line, and it's a consideration you want to make before you accept a job there. And then from the collected billings, you're going to generally deduct disbursements. The big one is obviously laboratory fees, but you have to be careful on what exactly they're deducting. So generally, if you're working for a dentist who has a single practice, standard language will be they'll deduct laboratory fees. You may see they deduct collection fees, so credit card fees. If they have to go after a patient who hasn't paid, there's costs to that. That's all going to impact your bottom line. And then if you're working for some of the corporations, it gets much more complicated in terms of what they're deducting. You could see material expenses. So you've got to really look at the contract, understand how you're being paid and what's going to be deducted from your collected billings. So generally, you're being paid a percentage of collected billings. Okay. So, standard right now is 40% of collected billings. Maybe if you go in Northern Ontario, you may be looking at a higher percentage. If you're a specialist, it's going to go up from there a little bit. But 40% is generally what you're looking. I've seen in rare circumstances that number coming down a little bit, high 30s. But, if you're under 40, I think you need to question that at this point. You also want to make sure in that associate contract that it allows you to get a billing summary of the practice on a monthly basis or whatever it may be, to ensure that you're comfortable with what's actually your work that's actually done is you're getting paid. And you want to see what the collections are, you want to see what the lab fees are, et cetera, so that you make sure you're getting paid what you deserve. If you don't have a provision in your contract to that effect, you may not be getting what you deserve. Now, most principal dentists are honest, and I don't see this as a problem. I sometimes do, but you want to make sure that contract clearly states what are you getting, what information are you allowed to see to make sure you're getting paid what you are entitled to. So non-compete, non-solicitation. So what I was talking about before is it's very important for the principal, and this is what I tell all my dental clients who own practices: do not hire an associate unless they have a contract, because if they don't have a contract, your goodwill is in jeopardy, right? That's the value when you sell a practice. The biggest part of the value of that practice is the goodwill. Goodwill is sort of this idea. It's not a physical, tangible piece of equipment. It's not a leasehold improvement. It's how many patients are coming back on a regular basis. And if you haven't, and I've had this situation happen many times with dentists, or I get a call from an associate saying, I've worked at the practice for 20 years and I want to open up nearby. The principal said he was going to sell the practice to me. He never does. And I'm fed up. I want to go work somewhere else nearby. Do I have any issue there? And the first thing I say is, do you have a contract? When they say, no, I don't have a contract, I say, well, you have no non-compete, you have no non-solicitation. You could go open up next door, take those patients, take the staff, and there's not going to be much that the owner is going to be able to do, right? So that's why in those associate contracts, you have the non-competition and non-solicitation covenants. So what's a non-competition? So non-competition means you cannot practice dentistry within a certain radius of the practice. So you take the practice as the middle point and you draw a circle around it. Depending on where the practice is, that's going to impact the size of that radius. So if you're in downtown Toronto, maybe 1 kilometer, 2 kilometers, that would be sufficient to protect the principal, right? There may be 10 other practices within that vicinity. If the principal's asking you to sign a 5 or 10 kilometer radius in downtown Toronto, it's not reasonable, it's not going to make sense to you, I wouldn't sign it. Now, if you're Northern Ontario, more rural area, that radius is going to increase, right? There's less practices in the area. They don't want you to be 10, 15 kilometers, maybe it goes up to 20 to 25 kilometers. Keep in mind, the courts in Ontario have generally held the view that non-competes against associates are not enforceable. So if you were to breach it and the principal took you to court, that non-compete may not be enforceable against you and you'd win that case. We've had that situation happen in several circumstances where our associate clients have breached the non-compete, opened up nearby, and twice with some of the big corporations, they've been sued. Our clients have won both times, but it costs our clients about $50,000 in legal fees. So I always say, sign the non-compete, planning to abide by it, because you don't want to get into a fight with Dental Corp or 123 or one of the other big corporations, because they'll fight you just to prove a point. Non-solicitation means you can't start stealing patients from the practice. It also means you can't steal employees from the practice, right? That'll be a problem. Sometimes in these contracts, sometimes with the big corporations, you'll see penalties for setting up within the restricted radius. Sometimes you'll see 50,000, 200. You'll see penalties from hiring away employees, 25,000 for an assistant, all the way up to 250,000 if you hire away an associate. Now, it's questionable whether those are going to be enforceable in court, but a lot of that is to sort of scare the associate when you sign a contract and make sure that you're going to abide by it, because you don't want to call me and say, I have a $250,000 penalty if I steal my friend over to my practice. I would tell you, don't even start fighting with these guys. It's not worth your time. It's going to cost you a lot of money. The other thing is, get your lawyer to look at the contract before you sign it. I'm going to look at some of these provisions. I'm going to tell you, is that a reasonable radius? Is $250,000 reasonable to hire an associate? Let's get those terms set up to your advantage before you even sign it. So later on, you don't have to come to me and say, I signed this contract. I didn't know what I was signing. Do I have a problem here? You might have a problem. We want to cut those problems off right at the beginning, right before you even sign the associate. So you're comfortable with the associate contract before you sign it. That's the most important thing. So additional items to consider as an associate: you're considered an independent contractor rather than an employee of the dental practice. That's an important distinction, especially from a tax perspective. From a legal perspective, you have to understand that you don't have the same rights that many employees do. So, in that associate contract, there would be a provision that would allow the principal to terminate your contract with certain amounts of notice. So whether that be 30 days, 60 days, 90 days, you're not going to have the same termination rights that an employee would have. So there's no termination pay. There's no set amount of time that the principal would have to give you to terminate that contract. It would all be set out in the agreement. Likewise, you want to ensure there's ability for you to terminate that agreement, right? Now, I've seen associate contracts that will fix the term for 1 or 2 years, and they don't provide any right for you as the associate to terminate the contract. which can cause a big problem. If you're not happy with the contract and you're not happy with the dental practice, you want to have an ability to get out of the contract without causing any damages to yourself by breaching the contract by not keeping within the term of the contract. So be very careful of that. Okay. One other thing, going back to the non-compete, non-solicited termination, one provision that I like to add to contracts if possible is it allows you to, if you have, let's say, a 60-day termination provision that allows you to terminate that contract at any time. I like to put sort of it's a period which would allow you to sort of get comfortable with the practice before you commit to that non-compete. I don't want you to start at the practice, work there for 60 days, realize you hate it, and now you're stuck with a non-compete for 2 years for 5 kilometers and you can't work anywhere else. So I like to put a provision that if you terminate that contract within the first, let's say 60 or 90 days, that non-compete is not going to be enforceable against you. And usually principals will allow that. It's a reasonable request. It protects you if things go south with the relationship early on. It doesn't get you stuck in the non-compete. So once you started working as an associate at a dental practice, you start making some money. The next step you would need a lawyer for is to incorporate a dentistry professional corporation. Now, a dentistry professional corporation requires your lawyer and your accountant to work together to incorporate for you. The first step would be to go to your accountant, and usually you would be going to your accountant on an annual basis at least to get your taxes done. Your accountant should be looking at your financial situation on an annual basis. Is your what's your student debt? What is your other debt? Does it make sense at that point to start incorporating you? Especially if you're buying a dental practice, you're going to incorporate a dentistry professional corporation. When your accountant tells you that it makes sense for you to incorporate, that's when I would get involved as the lawyer. Now, just to tell you what the advantages to a dentistry professional corporation are. I have some numbers here, but these fluctuate. So this just gives you a basic idea. Within the dentistry professional corporation, money that you're taking in, you're getting taxed at approximately 15%. It's actually a little bit lower than that. If you're getting the money paid personally to yourself and you're at the top tax bracket in Ontario, you're looking at 54%. So that's a massive, massive difference in terms of what you may be paying in tax. And so you can see there's a huge tax advantage to incorporating a dentistry professional corporation. Keep in mind, and this is also what you have to look into.
Can I ask a question,
Absolutely.
Michael? Because it's actually related to what you just said. Well, you're comparing here the tax bracket to the maximum, to the highest tax
Correct.
bracket. But discussing with, when we're having conversation with newly licensed dentists, they're not necessarily jumping to that bracket immediately.
100%.
So what does that transition period ideally need to look like? How much of a leeway does a new associate have until they reach a point where they have to incorporate, or where it's practically beneficial to incorporate?
So there's no specific number. You got to look at your financial situation. So remember, the tax savings is only the amount that you're able to save in your dentistry professional corporation. Once you take that money out into your personal hands, you're back to where you were. You're paying that money. You're getting that taxed at whatever tax rate you're at. So you have to look at what tax rate are you at based on what you're making. How much money are you able to save?
Let me put out a scenario,
Sure.
if I may. Like if someone is expecting to make $100,000 to $150,000 in their first year of employment, what is it recommended for them to incorporate from day one, from the word go, or would you give them a year or 2 years because they're going to build up their income?
It depends on your lifestyle, right? If you're making $100,000, but you need to pay down your debt, your school debt, and you have to pay your mortgage, and you have to pay for your car lease, and you're paying $100,000, and you're not going to save anything in your corporation, there's no point of wasting the money to incorporate, right? If you're making $150,000 and your cost of living is $50,000, it may make sense to incorporate at that point. But the same way, if you're making $500,000 and you have a $10 million house and a Ferrari and you're spending all your money personally to fund your expenses, it doesn't make sense to incorporate. So it's a case-by-case basis. Most dentists don't incorporate within the first year. It just doesn't make sense. There are costs, so legal costs, your accounting costs, and ongoing annual costs. The RCSO charges you to incorporate. They also charge you on an annual basis for your certificate of authorization. So you've got to factor all the costs, all your personal living, how much you can save, and then at that point, run the numbers, determine whether it makes sense for you to incorporate. Most, I would say most dentists by year one or after year 1 or 2 are thinking about incorporating at that point. If they're buying a practice earlier, for sure at that point, you're going to incorporate. You're going to own the dental practice.
I'm just
within
going to
your
repeat
dentistry.
this just to make it clear and to underline the fact that, you know, the driver of the decision to incorporate not just relies on your top line income, but your lifestyle, which means how much of that income are you spending, and the more you spend and the less you save, the lesser the incentive to incorporate.
Exactly. You've got to look at it as the dental professional corporation is your savings bank. If you're not saving anything, there's no advantage to it. There's no point of incorporating. So you nailed it right on the head. So you're on an annual basis, you got to talk to your accountant, see if it makes sense based on where you're at financially. But there's definitely a huge advantage.
Is
from
there
a
a
tax
ballpark cutoff saving that kind of where the incorporation is kind of starts to become?
There's no magic number. Obviously, the savings have to be higher
There's
than
tax brackets involved, right? So those don't change. So referencing from those tax brackets, can you provide a guide?
I can't give an exact number. It's just when you're making, and it's also a question for the dentist whether they want to spend the money, right? From a legal perspective, you're looking at around $4,000 or $5,000, and then accountants probably the same thing. And then on an annual basis, you got to do your corporate financial statements, and you've got to do your annual minutes with your corporation. So, you know, you could be looking at another three or 4,000 on an annual basis. So if you're saving less than that, there's no point to doing it. So you've really got to crunch the numbers and figure out the timing on that. But most dentists are doing it after a couple of years. There's also other tax advantage. If you own a practice, there's what's called the capital gains exemption. It allows you to sell shares of your dentistry professional corporation, which most dental practice sales are structured at, so that you can essentially pay no tax on the capital gains. Each person, and again, it's a fluctuating number on an annual basis, gets $850,000 tax-free. And then you can multiply that by every family member who's an equity shareholder in your corporation. So you can add your spouse, you can add your children, you can add your parents. And again, we don't need to get into all those details. There's issues with adding certain family members, but you can multiply that capital gains exemption by the amount of family members that are shareholders of your company. Okay. So in terms of selling or buying a dental practice, that's likely going to be your next step. Now, you know, I just, not a legal issue, but some people will be dental associates for their entire career, and I think that's fine. Some will buy or sell a dental practice and hopefully sell that one day in the future. But it doesn't necessarily mean, you know, your associate. Do not feel pressured to buy a dental practice. You know, be comfortable. You know, make the right decision for you when you are ready. If you never feel like you want to own a dental practice, don't feel pressured to buy one. It is a business, right? And you know, you can, if you're an associate, you can make a very good living being an associate for your entire career. You go, you do your dentistry, you don't have to worry about all the problems that I see from a legal perspective. So employees and your landlord and dealing with the bank and all these administrative headaches throughout your career that are just extras. And building up a practice, a patient base. These are not easy things, especially now when dental practices are on every corner, especially if you're in the GTA or Ottawa or, you know, some of these bigger urban centers. So you've really got to consider how much time you want to expend. Are you a business person? Is owning a dental practice the right move for you? Okay. The first step to either buying or selling a dental practice, obviously on selling if you already own one, get the right team around you. Okay. That's to me the most important thing. So who's your team going to be? Your accountant, extremely important team member. They're going to look at the financials of the practice. They're going to look to see, is the purchase price that you're offering, does that make sense? In due diligence, which I'll get into in a second, which to me, your accountant's role is the most important in the whole transaction. You want to make sure you're paying a lot of money for this dental practice. You want to make sure that you're getting a fair price. You want to make sure there's no issues in terms of financial, our billings, do those line up with bank statements, and do the financials make sense? And what's their collective billings? And, there's a whole laundry list that these accountants are checking, especially if it's a share deal. I'll get into that a little bit later. There's a little bit more risk from a purchaser. Then you have your lawyer. Hopefully it's me, but make sure you're interviewing several lawyers. You want to make sure that there's a comfort level with whoever your lawyer is. You want to make sure that you and them are on the same page. Someone you're going to be on the phone with that lawyer on a consistent basis for what could be months. So you want to make sure you obviously like that lawyer. And you want to make sure, to me, one of the most important things about getting anyone on your team, make sure they have a lot of experience dealing with dental practices. Whether it be your accountant, your lawyer, your banker. I do so many deals and I run into lawyers or accountants who don't ever deal with dentists, and it slows down the deals. There's mistakes. It can become problematic and it can really impact your transaction. So you want to make sure that whatever lawyer accountant you use, and if you ever have any questions, I'm happy to introduce you to whomever, as I know who deals with in this industry. Just make sure they know what they're doing and have a conversation with them. Get a feel to make sure that they understand the nuances in the dental industry. And to me, that's who you're relying on. That's who you want to make sure is on your team to have a smooth transaction. So I have here a roadmap of what your typical transaction is. So if you start looking for a practice, generally what you're going to start doing, you're going to sign up for the dental brokers. They have listings and they'll send out listings for all the dental practices they may have for sale. You may be a part of associations, and at those associations, you may talk to dentists. Colleagues may be selling that So there's all these different ways that you can sort of find either a broker deal, which I would say make up, probably around 50% of the transactions out there, or, at these associations, an older dentist doing a private deal, you may be able to find that type of transaction for yourself. Or you may be associating at a practice and the principal likes you and wants to sell to you. Those are generally the ways I see that the transactions start. So let's say you've found your practice, you want to put an offer on. So then at that point, you talk to your accountant, you talk to your lawyer and say, I found a practice, I went to the open house, I have an appraisal done by one of the appraisers, and I want to put in a letter of intent. A letter of intent is a 3 or 4 page document that sets out the basic terms of the deal. So you'd have your purchase price. Is it going to be a share deal? Meaning, are you going to buy the Dentistry Professional Corporation, or is it going to be an asset deal? What are the conditions? Is it going to be others? Are you assigning the lease? Is there going to be a financing condition, a due diligence condition? When is the closing date? The closing date is the date that the practice transfers over to you. Structuring the deal. So with the help of their accountant, your accountant, is it going to be a share or asset deal? How long is that due diligence period? So once the letter of intent is signed, you start your due diligence. You start doing the purchase agreement. So at that point, your lawyer really gets involved doing the asset or share purchase agreement, which in relative to the letter of intent is about a 40-page document. And that contains all the protections, representations, warranties, indemnities for the purchaser, to make sure if anything goes wrong after closing, or hopefully everything goes wrong after closing, that you're protected. You can go back and if there are problems, sue the seller and try to get some of your money back, or try to protect yourself in whatever way it might need to be done. Once your financing is approved by the bank, once your due diligence is done, once the purchase agreement has been signed, once the landlord has approved the lease amendment or change of control of the lease, or you bought the property, whatever the deal may be. Then we go towards closing the deal. Now, I've given you only three little points here. That can take as long as 6 to 9 months. I generally say on a good deal, once the letter of intent is signed, 60 to 90 days if everything's smooth. With COVID, things have slowed down, the banks have slowed down, so things seem to be taking a lot more time. Landlords have been bombarded by their tenants asking for rent reductions, so they've been dealing with that. So they're slow. Everyone's slow because of COVID. So maybe we're closer now to an average of 120 days. So 4 or 5 months to get a deal done. But I've done deals that have taken 2 years to get done. So that's not the norm.
And we were recently involved in one that took a year, Michael.
Yeah. So that's right. I mean, there was a delay because of COVID of about 3 or 4 months. So, maybe it would have taken 6 months if there was no COVID. But yeah, definitely some of these deals take a year. That's not the norm, right? And there's reasons for that. Landlords can take a long time. Negotiating the purchase agreements can take a very long time as well if there's disputes about certain provisions. So we've talked about the letter of intent, and I'll get into more details about that. So again, just going back to the point about dentistry professional corporations, you're going to want to buy the practice, whether you're buying assets or shares through a dentistry professional corporation, and that's going to be expected by the bank. Just going back to the capital gains exemption, one of the big reasons you want to own through a corporation, first of all, you want to be paying the bank debt back with corporate money. You don't want to pay from your personal funds because, again, not good from a tax perspective. And again, when you sell, you're going to get that capital gains exemption, massive, massive tax savings. So it just makes sense from a tax perspective. One thing I want to just mention about dentistry professional corporations. One reason people generally incorporate, not just regular companies, not dentistry professional corporations, is liability protection. So let's say you enter into a lease and you have a holding company, something like that, and you're not personally guaranteeing that lease. The landlord can only go after the corporation on the lease. They can't go after you personally unless you've given a personal indemnity. Now, one distinction with a dentistry professional corporation, when you are doing dentistry work, you are personally liable for that work. So you can't say, well, I'm practicing through a company, I'm protected, you can't sue me personally. That is not correct. It is a distinction that you should be aware of. Now, you do have PLP insurance to cover you for any work that may go wrong. So you are covered by insurance anyways, but I just wanted to make that distinction for you. So I mentioned briefly share sales versus asset sales. So what is the difference in terms of share sale versus asset sale? So I'll try to visualize it for you. The seller is going to have a dentistry professional corporation, and they either will sell the shares of that dentistry professional corporation. The shares is sort of the ownership of that corporation. Now, because of the capital gains exemption, most dentists want to sell shares. So from a purchaser's perspective, that means you're actually buying the shares, you're actually buying their company. That company owns the dental practice, so you're going to own their company, and then we amalgamate them. From a purchaser's perspective, there's more risk to you. The reason being is because when you buy the dentistry professional corporation, you also buy any hidden liabilities that might be in that corporation. So for example, a big concern is often, has that corporation not paid taxes? If they haven't paid taxes and the CRA comes back after closing, they're going to be coming after you, which isn't fun. In the purchase agreement, we have protections that say, if this, let's say it was the CRA or a patient came back and sued, it still remains the liability of the vendor. So you then have to go sue the vendor. Still not fun to do, but generally it's how most deals in dentistry work, because we've been in a seller's market for a long time, even including during COVID. An asset deal is a little bit different. Purchasers prefer asset deals. You're buying the actual equipment, you're buying the goodwill, the leaseholds, all of that. You're not buying the company. That still belongs to the vendor. You have nothing to do with that. So you avoid that risk that you have with a share deal. Okay, so keep that in mind when you're buying a practice. In a perfect world, as a purchaser, you buy assets, but we're not in a perfect world for buyers. So generally it is share deals. But keep that in mind just so you are aware. Make sure your lawyer, accountant have the right clauses in your agreement to make sure you're sufficiently protected.
And basically, when you're buying, when you're in a share deal, you're buying the DPC of the seller. Is that right?
That's correct. So
So,
the structure is generally your DPC, your Dentistry Professional Corporation, buys their DPC. So for a moment in time, your corporation owns their corporation. Because the RCDSO does not allow a corporation to be a shareholder in another corporation, we then amalgamate the two companies. The company's still known as same name as you had before, so it'd be whatever your, Dr. Abbas Naqvi Dentistry Professional Corporation, but it's now an amalgamated entity. Those two corporations become one, and that's the owner of the dental practice going forward. So the definitive purchase agreement, AKA the offer. So depending on, some brokers, they'll do the offer for you. Roy Corp will do it for you. MBC Brokerage, they'll actually do the purchase agreement for you. Make sure there's a lawyer review if you're going to sign that agreement because it is a binding document. The lawyer review condition allows your lawyer to check the agreement, make amendments that they think are necessary. But generally, you're doing a letter of intent. So a letter of intent is non-binding. It allows you just to agree on some of the basic terms. But the binding agreement is the definitive purchase agreement, also known as the offer. So in that purchase agreement, we'll have representations and warranties. So the seller makes representations and warranties about the practice, the corporation. So for a very simple example, all co-payments are being collected by the dental practice, right? So we want to make sure that co-payments are being collected and the vendor saying that. If after closing that turns out not to be true, you walk in and a patient says, well, Dr. X never collected co-payments. Why are you collecting for me? And now that patient says, I'm leaving. Well, you've suffered some damages there. And if that happened to enough patients and you've suffered enough damages, you would consider suing the seller on a breach of representation, right? And there's probably 50 or 60 representations and warranties. That's just an example. Then you have your big condition, so your financing condition. So the deal is going to be conditional upon the bank approving your financing. Your lease assignment, the purchase agreement is going to be conditional on the landlord approving the assignment of the lease to your new corporation, and the due diligence condition. So you want to ensure that due diligence, it meets your satisfaction. If it doesn't, you can walk away from the transaction. You get your deposit back. Due diligence, the most important part of any transaction for a dentist. I've said a little bit about suing a dentist after closing. You don't want to do that. It's expensive. It is time consuming. You want to make sure if there are any problems that you try to find them out before you close the transaction. And if you're not happy with the due diligence, you have the ability to walk away from the transaction. No harm, no foul. I'd much rather you walk away after, even if we spent some time, some work, some money getting to a certain point, you're going to spend a whole lot more money later on fighting or suing or not being happy generally if you're not happy with the practice that you got. Due diligence means your accountant's going to go do their financial due diligence. Your lawyer's going to look at employment contracts, associate contracts, lease. We do legal due diligence, legal searches. You're going to go into the practice, do chart counts, check the equipment. There's also consultants who can do that for you. You want to make sure all your equipment's in working order. You want to make sure the appraisal that you're relying on is accurate. Don't just look at the appraisal, say the broker said there was this many patients, there's this much revenue. Don't rely on that. Do your own due diligence, be comfortable yourself. Assignment of the lease. I was on the phone with a broker at 5:30 yesterday. We've been working on a deal since before COVID, so I think it started in February this year. And there was a lease negotiator. One of the big landlords represents my client as my client's landlord, and one of the lease negotiators has told us back in March, we're going to get there's a demolition clause in lease. We're going to get that pushed out for 12 years, meaning the landlord can't use it for 12 years. The demolition clause allows a landlord to terminate the lease if they want to redevelop let's say it was a plaza. The issue with that is it's difficult in certain circumstances to get bank financing if there's a demolition clause, so a lot of buyers don't close deals. The landlord at the last moment said, we're not going to get rid of that demolition clause. And so that's jeopardizing the deal right now. The deal may not be able to go forward. So, your lawyer, or a lease consultant, if that's what you engage, need to review the lease, make sure you're comfortable with it, get it to as good a point as possible. Now, there's nothing that requires landlords to make amendments to that lease when you assign it, but you want a minimum term on that lease that matches the amortization of your loan. So for a long time, it had been 10 years. So you want to make sure you have 10 years of term on that lease, including renewals. Now it's 12 years, a lot of banks are giving. So if you have an amortization of 12 years, you want to make sure that, that lease is a 12-year term. Ideally, you're going to try to make sure there's no demolition clause. There's many, many other tricky clauses in those leases that you want to have someone review for you, because they could cause you problems down the road, or just may not make it practical for you to buy that practice. I have a point there. Actually, this point here is interesting because landlords are making it more and more difficult to assign the lease. They're reluctant to make any changes. My view is COVID is changing hopefully for the better, and I'm not sure how long it will last. Dentist relationship with landlords, obviously commercial real estate has taken a hit during COVID. I'm hoping that landlords become more amenable to dealing with dentists on a fair basis, because dentists are AAA tenants. You don't want to lose them, especially in this market. And so, hopefully they can make some changes to those leases and make deals easier. But generally, landlords and the lease can be the most difficult part of any transaction, and most time consuming, because some of these big landlords, they can certainly take their time. Just one other, point here, an anecdote that I did a deal. Dentist was on Bloor Street in Toronto. A renewal option had been added to her lease about a year before she closed. And the renewal language said, when I say renewal, it allows her to renew the lease for 5 more years, said it only applies to her. It doesn't apply if she sells the dental practice. So when we went to go sell the practice, help her sell the practice, the landlord said, sure, we'll give the renewal option to the new tenant, but you have to pay me $100,000 to do it. It wasn't a big practice. We begged and pleaded to the landlord, please, purchase price is $600,000. $100,000 is a huge burden, obviously, for the seller. And he said no. And the only way we could get the deal done is if my client paid the landlord $100,000. So she did. Now, the way I explain it is it actually is not the worst case scenario. The worst case scenario would have been if the landlord said, no way am I giving the new buyer another 5 years. If that happened, now you're selling charts and the price goes down significantly. So unfortunately, this is a daily occurrence. The landlords take advantage of situations. They either ask for money, they don't make the changes that you need to get deals done. It happens all the time. So, making sure you're getting a decent lease, making it as good as possible is always the best thing when you're doing one of these transactions. Associate agreement. So just 2 points on the associate agreement. First of all, the seller, as the vendor is going to likely transition for a period of time, and they'll enter into their own associate agreement. So that's part of the transaction. The other thing you want to make sure is, does the vendor have associate contracts with their associates, right? Because you also don't want that associate to leave in the future and open up their own practice nearby and steal some of the goodwill that you're buying. So non-compete, non-solicit, just a little bit of a clarification. When I said non-competes were not enforceable against associates of the practice, that does not apply to a seller. Non-competes are enforceable against sellers of practice. Now, obviously, they've gotten a huge amount of money to sell the practice and you've given them. So courts will uphold those non-competes, and they're extremely important. You don't want that dentist opening up nearby or stealing patients. So really important to make sure those are in place. So vendor to associate post-closing. Just one other point on this. You want to make sure during the course of the transaction, you keep a good relationship with the vendor. Really important part of transition is making sure you haven't soured your relationship with the vendor. If you try to reduce the price for whatever reason, really consider whether it's worth it, because I've had so many times I've acted for sellers who end up not liking the purchaser and aren't as helpful as we like them to be in terms of the transition. So make sure you're trying to keep as good a relationship with the seller in the course of the transaction. That will really help the transition as you go along, especially if they're so associating with the practice following the closing. Employees, we check for employment contracts. A lot of the times, even if there are employment contracts, they were done improperly. There was a case that came out in July of this year, which invalidated, I've heard upwards of 90% of employment contracts in Ontario, which is a staggering number. And when I say invalidate, one of the most important parts of the employment contract is limiting your termination liability should you want to terminate that employee after closing. That's the most important thing of these employment contracts. So many of the employment contracts, when I'm doing due diligence for the buyer, are not done properly. Oftentimes you can't get them signed before closing. So assuming that the employees have not been there for too long, there's not too much termination liability, my advice is, 6 months to a year, start thinking about trying to implement new employment contracts. It can save you money down the road in terms of if you ever want to terminate someone, your termination liability is going to be limited. I'm not going to get into all the details of termination liability, but it can go quite high if you have no contracts in place. So that's just a little bit of background on how termination liability works. Again, if you have the good employment contract in place, it will limit your termination liability to 8 weeks, which is what's under the Employment Standard Act. You won't get that common law. Common law is where you probably heard 24 months, a month per year. That's when it can go much higher. So closing the transaction. So once all those conditions are waived, so your big ones, financing, due diligence, you have the lease consent, we start working towards the closing, which is doing your closing documents, which include your associate agreement, non-competes agreements, health information custodian agreements, all that fun stuff. And then once we've exchanged signed documents between the lawyers, the bank sends the funds to the purchaser's lawyer and sends it to the seller. We can close the transaction. Then you become the owner of the practice. Just a little touch on corporate entities. They're becoming bigger and bigger in Canada. Dental Corp alone has 300 clinics. That might be an outdated number. Revenue of 500 million. So they're, more and more of the deals that we're doing are with corporate entities. So if you are selling, or if you're so associating, very important right at the outset, get your lawyer and accountant involved. The transactions with the corporate entities are much more complicated than dentist to dentist. So you want to make sure before you sign a letter of intent that you have your advisors really reviewing those contracts to make sure you're getting what you're expecting, because the structures are much more complicated than just a regular transaction.
We're just approaching time, so just we'll keep in.
Yeah, I'm wrapping up here.
There'll be some questions as well, right? So.
Okay, yeah, okay, that's done. So the biggest issue is just to summarize the lease. No associate contracts in a purchase. Your dentistry professional corporation is not being done properly. No employment contracts, and practices aren't being run in accordance with laws. So not collecting payments, IPAC, etc. So that's it. Yeah, if you have any questions, please let me know. I'd be happy to answer them to the best of my ability.
Thank you, Michael. Amazing summary of what we went through. It took us a whole year to go through that transaction, and everything resonated so well. What every word that you were saying, kind of I was living through the
some bumps in the road, but we got there.
Everything that you said I was reliving the last year.
And hope not nightmares.
Yeah, all's well that ends well. If there are any questions, we can quickly take them before I can see the and that's what I love about Neil, the tenacity in his eyes, the smile on his lips, and he's thinking and he wants to just jump on it and beat the hell out of that subject. So I know he's keen to do that, but if there are any other questions, I'll just give a minute for people to maybe collect their thoughts. And if you have any quick question for Michael, the session is being recorded, so obviously there will be lots of time to go through it again. But if there are any questions, we will take them now.